Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Brandy Thompson from the Kronzek firm, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome back to In the Name of the Law, a legal talk show about real people with real legal problems. Today's episode, we're going to talk about a criminal defendant who was wrongfully convicted and then exonerated, the collateral impacts of CPS cases on a criminal case, and pursuing a civil case for sexual assault. Stay tuned.
In the name of criminal defense.
Welcome back, Mary and Takura, the attorneys from Chartier Nyamfukudza. So you recently had a fabulous victory where you had a client who was exonerated. This means that your client was wrongfully convicted and wrongfully imprisoned. I know you're still excited about the victory in this case, and we want to hear all about it. Can you tell us the allegations that were made against your client?
Yes, we are excited and will be for many years to come. So Lucino Hamilton, as you mentioned, was falsely accused of one of the most heinous crimes imaginable, murdering his mother. And supposedly within 24 hours of arriving in the lockup, confessed to a stranger that he murdered his mother. Ultimately, he was convicted by a jury and spent 26 years in prison. 26.
So he wasn't your client at trial or on appeal. So how did it come to be that you were representing him?
So originally, Mr. Hamilton wrote letters, thousands and thousands and thousands of letters to people all around the country, hoping that someone would help him and take his case. The University of Michigan Innocence Project screened the case. They thought he was innocent, but they didn't think they would be able to prove it. Ultimately, Mr. Hamilton made his way to Claudia Whitman at the National Capital Crime Assistance Network, and she reached out to us. She's a private investigator. She was working on the case pro bono, asked us to take it. We really love a challenge, so we thought, well, we'll take it. And then for 6 years, we worked on it for him to get released.
So what did you learn from working on this case?
Ooh, a ton. A ton.
Right. So
I know you've worked on other exoneration cases. This is not your first exoneration victory. But let us hear about this one.
no, it's not. But after much investigation, we learned that this person who Mr. Hamilton supposedly confessed all these details to had testified against a lot of other people. I think easily a dozen. And he was supposed to go to the Department of Corrections, MDOC, but never did. He had his sentence reduced magically, and there's no court rule or case law which served as the basis for this mechanism. So there was a lot going on. Memos from the Wayne County Prosecutor's Office talking about this practice, secret sentencings. It's the stuff movies are made of.
And the interesting thing, Lisa, is originally we thought this was about this one man and Mr. Hamilton, that this man essentially jumped on Mr. Hamilton's case, meaning that he doesn't know anything about Mr. Hamilton's case, but he learns it from somebody in the jail, right? And we see that a lot where someone says, oh, I supposedly this guy confessed to me in the jail, or I really was dealing drugs with him outside, but there's no evidence to support that other than what they say. Ultimately, as we worked on it more and more, Takura, me, everybody at the CNN team, we learned that he was a serial liar. This guy would claim that all these people confessed to him in the jail. What's remarkable is on the date that he said Mr. Hamilton confessed to him. So at the preliminary examination, when he went to court and said Mr. Hamilton confessed to killing his mother, on that date, Mr. Hamilton hadn't even been arrested. He wouldn't have even been at the jail. He had facts wrong about the case, timelines wrong. I mean, he's not a priest where people are confessing to him. He would say, well, he said he walked by Mr. Hamilton's cell and Mr. Hamilton confessed murder to him. I mean, it's absolutely ludicrous, but a jury bought it, right? the police were in, and ultimately this becomes an issue where Takura, Lizzie, everybody is digging into this. And we learned that the police never moved him out of the holding cell. So this witness was supposed to go to the Michigan Department of Corrections. They never brought him there. They kept him in the holding cell where he would claim that people confessed to him. And we knocked on doors, went to prisons. Takura and Lizzie spent days digging through files in the basement of the Wayne County Court.
Right.
When we would look at lawsuits that had been filed, and we would try and track down witness, cases where this guy may have been a witness. We'd reach out to people in the prisons. It was a tremendous amount of legwork.
So you're investigating Mr. Hamilton, your client's case. You're looking into all the other cases that this witness, what can I call him, a jailhouse snitch? That
you can. I mean, but he's a liar, right? Because snitch to me is like Takura and I, played baseball. I broke the window. Right, he snitched on me. Right. So, but what we found when we first started digging into it, we thought this was about the impossibility of Mr. Hamilton ever having made these claims to this witness. But once we started digging into it, it became, in my opinion, and Takura's and everyone's, a stronger case and much more pervasive, because he had done the same thing to numerous other people. And Ramon Ward is another gentleman who was exonerated, and this guy testified in his case. Same thing, same exact thing.
Do they go back and look and see has anybody investigated, to see, let's look at all the cases that this person testified in to examine whether they're, wrongful convictions?
Well, one of the problems is, how do you find all those cases? So we sent, I'd say dozens, if not more than 100 Freedom of Information Act requests. We'd send them to the police. We sent it to the prosecutor's office. We'd send it all over the place to try and figure out who he testified against. We were told there's no mechanism for the prosecutor to track it. And we were told by the police they didn't have any files on this guy. He also had almost 30 aliases that he used. Now, he supposedly died, but he actually picked up new charges in one of the aliases after he was dead. So there is a death certificate showing he died, but again, the jury's always out on that, at least according to me. I'm like, how do you pick up charges after you're dead? So it's tough to recreate all these cases. I think the Wayne County Conviction Integrity Unit, and they ultimately get involved in the Wayne County prosecutor, Kim Worthy. She's the one who signs off on his release, and then Judge Tracy Green signs the order for his release. But the Wayne County Conviction Integrity Unit, they have done a remarkable job of taking the information we gave them and then building on it and building on it and building on it and trying to find out how many cases he testified in. And the other thing that we didn't mention is there was actually DNA taken from under the victim's fingernails in 1994 that had never been disclosed. The Conviction Integrity Unit is the one that actually physically went to the file and found the DNA. Then the Cooley Innocence Project gets involved, and they talk about and they handle how the DNA is going to be processed. And then the Idaho Innocence Project gets involved to look at the analysis of the DNA results. So once a Conviction Integrity Unit gets involved, then all these other people were able to pull in to get this great result for him.
And teamwork made the dream work.
Yeah. But you probably filed a motion as well, the evidentiary hearing and all that.
So we were getting ready to file what's called a post-judgment motion, a 6500 motion, and then we opted to go the Conviction Integrity Unit route. And then we gave them all of our pleadings and all the exhibits that were going to go along with it. This resulted in his release faster, for sure.
Tell us about the day that Mr. Hamilton was released.
Picked him up. Everybody was crying. There wasn't a dry eye. A group of us were in the parking lot, and I drove him. He sent his first text message to me. And I took him for the biggest steak he's ever had in his life. It was as big as his arm.
It was, the look on his face when he walked out was amazing. I mean, he was just in shock. The one thing he wanted was a pair of sneakers. He wanted to get out of those prison shoes. Takura bought him a pair of sneakers. It was like Cinderella. He got him to the car, put the shoes on. If anyone is interested in hearing more about this remarkable story, how it was done, all the work that went into it, and from Mr. Hamilton himself, please check out the Constitutional Defenders podcast. We've got a lot more about this great case.
And congratulations, your hard work paid off.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. In the Name of Family Law.
Today, we're going to talk about the interplay of CPS cases and criminal cases. We have with us Brandy Thompson, who is a partner at the Kronzek law firm. Brandy has devoted her career to working on CPS defense cases, and other attorneys at her firm work on criminal cases. Welcome back, Brandy.
Thank you, Lisa.
So parents are often confused when there's a CPS case or when CPS is conducting an investigation, and then when the police want to talk to the parent. Can you explain why that is?
Yes, Lisa. Oftentimes in CPS cases, the allegations that the parents are dealing with may rise to the level of criminal consequences as well. So there might be concurrent investigations. CPS is conducting their investigation, while at the same time, the police may be conducting a separate investigation with regard to criminal charges. But you should absolutely be aware that both CPS and the police will exchange information and assist with each other's investigations.
So CPS frequently tells parents that they don't need an attorney. Is that true?
In some circumstances, it could be true. Again, CPS cases are absolutely on a spectrum of sometimes very mild cases and sometimes much more severe cases. In those mild cases, sometimes it's just a simple misunderstanding that needs to be cleared up. They could even have the wrong family or wrong kids, that they're knocking on your door and they're just mistaken identity. So sometimes you're dealing with that very, very mild case that can be quickly cleared up. And then in other circumstances, you're dealing with some very serious allegations. The most common ones that we see that are extremely serious are those involving sexual assault allegations and certainly infant fractures, broken bones of a child, where you're dealing with very serious allegations from CPS, but those will also rise to the level of a potential criminal investigation for the clients.
So I didn't think a person could be charged twice for the same crime based on the same allegations. How come there can be two different cases in two different courts?
Well, Lisa, criminal charges and CPS charges are two absolutely different cases. In criminal cases, the allegations or the charges are filed by the prosecutor's office on behalf of the people of the state of Michigan. The penalties are different. In a criminal case, a parent or the person being charged with a crime could potentially face fines, probation, jail for any term of months or years. And in general, the burden of proof is much higher in a criminal case than it would be in a CPS case. Alternatively, in the juvenile or abuse and neglect charges, those allegations are being filed by the Children's Protective Services Department, which is a branch of the Michigan Department of Health and Human Services. There's still a prosecutor, but in this case, the prosecutor is representing CPS as their client. There are no jail penalties in a CPS case, but arguably the penalties are a little bit more serious because it actually could result in the permanent termination of your parental rights. There are also lesser penalties, such as the temporary restriction of parental rights. Courts can order any number of services, such as drug testing, parenting classes, and there certainly could be also a temporary removal of the children in your home. And the burden of proof is generally lower. There's multiple at different stages, but the burden of proof is generally lower in a CPS case than in a criminal case.
So you make a really good point. I've heard that termination of parental rights is really the civil death penalty. And that brings me to an example from a case I remember reading about and talking to the family, where a man was accused of injuring his infant child. There was an unexplained head injury. And I know we're going to have a future episode about these unexplained head injuries. But what happened was he was charged criminally. But at the same time, the termination of parental rights case was on a much faster track. And I would like you to address the tracks and the timing. But the termination case was finalized, which means his rights were terminated. In the meantime, the criminal case was still ongoing, and he was later convicted. But the key thing in that case was that the Court of Appeals reversed the conviction because there wasn't sufficient evidence to convict him of the crime, and there was other errors that occurred in the case. But even though he was going to get a brand new trial and possibly be acquitted in the criminal case, the termination case was done, and there was nothing he could do to get his rights back for to have a relationship with his children or child. Well, it was actually 2 children were terminated, but 1 was injured.
Yes, Lisa, just like what I was talking about with the different burdens of proof that you have in the different cases, it's certainly possible to be convicted in one case or acquitted in one case and actually go through in the other case, which is why it's so important when you've got these different cases and these interplays to make sure that one's not rushing through the system and coming to a conclusion while the other one is still playing out, because you do have potential situations where the acquittal may actually help in the CPS case. I've also had cases involving both criminal and CPS case investigations, of course, where the investigation phase, the criminal investigation, the police conducting their investigation was actually helpful in helping us discover false allegations that were coming about that CPS had already filed a petition on. So you definitely have to pay attention. You have to be on top of both cases at the same time. These cases, you cannot treat them as wholly separate, because what happens in one case absolutely affects and has an interplay with what happens in the other case. And it's an unfortunate circumstance of what happened in the particular example that you're talking about, because it absolutely, evidence or witnesses or testimony that may have served to acquit in the criminal case may have been helpful in the CPS case.
So does the parent need 2 different attorneys, one for each case?
The only answer I can give is maybe. It certainly depends on the skill level and the experience that your particular attorney has in both areas. As I've kind of indicated, these are 2 very separate cases. Different Michigan court rules are applicable in each separate case. There's different burdens of proof. So you can have a single attorney if that attorney has the knowledge and experience and skill in both different cases. Otherwise, you'll want to make sure that you have appropriate attorneys that understand what's going on in the 2 separate cases, and they use their skill set in that particular area. And you want to make sure that they are working together and exchanging that knowledge and information on both cases if you do have 2 separate attorneys.
Let's talk about taking a plea in one or the other case. How do they impact each other?
Depending how your plea is done, if you plead guilty in one of the cases or plea responsible as it may be in a CPS case, that absolutely can be used as evidence against you in the other case. There are different ways that you can make a plea. There are different things that you can plead and structure that plea so that it doesn't have the same consequences or effect in the other case. So that's, again, you want to be very careful as to what you're doing in one case and how it's going to affect the other case, and make sure if you have 2 attorneys, they're working together and they're strategizing. Ultimately, when you are dealing with these allegations on multiple fronts, you need a team working together to understand your actions and how those actions affect each different case at the same time.
Thank you, Brandy.
Thank you.
In the Name of CPS Defense and Family Law is brought to you by the Kronzek firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
We often hear about people asking for damages for personal injuries through civil lawsuits, but we also hear about unfortunate incidents of sexual assault. Today, we are going to discuss the ways in which victims of sexual assault can pursue civil justice and compensation through the court system. We have attorneys Steve Sinas and John Homa from the Sinas Dramis Law Firm to discuss this important topic with us. Hello, Steve and John. Thank you for being here.
Hello.
Thanks for having us.
So, Steve, you regularly talk to us about interesting legal issues regarding matters dealing with personal injury in the civil justice system. Are civil lawsuits regarding sexual assault handled just the same way as any other personal injury case?
Well, one thing I try to stress in this show is that in personal injury matters, the law has different legal rules and issues depending how someone was injured or harmed. There are no universal personal injury rights we all have. And civil lawsuits dealing with sexual assault certainly have their own unique rules and standards. John is going to explain the unique area of federal law known as Title IX that applies to sexual assaults in public schools and universities. But before getting there, I just want to say generally that the perpetrator of an assault can be sued in a civil lawsuit. But unless that perpetrator has significant financial assets or wealth, there's not going to be much of a way to recover any financial compensation from that person. And also, insurance policies issued to individuals do not typically cover something like a sexual assault. They consider it an intentional criminal act and there's no coverage. So if you're just suing the person who commits the assault, there may not be any recovery. So you look for other entities or people that could be responsible for the assault.
Okay, so let's talk about that. How can you blame and sue another person or an entity for sexual assault that's committed by somebody else altogether?
So essentially what's happening is that there's a sexual assault that's been committed, and then there's an argument that that person's employer or someone responsible for that person, another entity or the property owner where the assault occurred, can also be held liable under the theory that they failed to take reasonable efforts to prevent the sexual assault from occurring. It's essentially a negligence standard. But the thing that people have to understand is that if you're going to make that argument and the entity you're dealing with is the government or a governmental entity such as a school system, that there's even a higher standard that applies. This is through governmental immunity principles. And this standard says you have to show gross negligence on behalf of that governmental entity in failing to prevent the sexual assault. That's a much higher standard than negligence. And it's really hard to prove. But what John's going to explain is how the federal law known as Title IX provides a recourse to victims of sexual assault in the context of a public school or university and how that area of law works.
Okay, well, John, what is Title IX?
Well, Title IX is a federal civil rights law that was passed as part of the Education Amendments Act of 1972. The law prohibits discrimination in schools that receive federal funding assistance, and it's all forms of discrimination. But the courts have also held that sex discrimination includes such acts as sexual assault or sexual harassment. And so it encompasses those situations when there is sexual assault within a school environment.
Can you explain the new Title IX rule?
Yes, well, the new rule was initially published by the Department of Education in May of this year. It became effective on August 14th. It essentially supersedes the existing regulations and the letters of guidance that were issued by the Office of Civil Rights regarding Title IX over the past 25 years. It further provides a framework for not only the grievance process in the school, but also for private causes of action. It's consistent with case law and decisions from the United States Supreme Court that have dealt with Title IX, and really with the private cause of action, it draws striking similarities, but there are also some nuanced differences.
Okay, so what actions would make a school liable for damages under Title IX?
Sure, well, essentially an educational institution will be held liable if an appropriate person within that university received notice that there was some type of inappropriate sexual assault or behavior occurring, and they were deliberately indifferent to that notice. In the context of elementary schools and secondary schools, any employee within the organization would be deemed to be an appropriate person, so that if they receive notice of some type of behavior going on, they would be required to take some type of corrective action. That's different for colleges and universities and post-secondary schools, where an appropriate person that needs to receive the notice would be the actual school board, the Title IX coordinator, or someone else who could actually take corrective action in light of that notice. So essentially, the concept is if the school receives actual notice that something's happening and they fail to act reasonably in response, then the survivor of the assault can bring an action, a private cause of action against the school for redress of their injuries. So it is an important law for survivors to seek redress for their injuries from schools that have failed to protect them.
So I have a few questions now. So does it matter who the perpetrator is? Does it have to be a school employee, or what if it's a student assaulting another student? Is that
so? There
is that
are
part of Title IX?
Yes. So there are two main avenues of Title IX claims. One area of the law focuses on teacher on student types of assaults. And there is a framework built in for the procedures and the processes that happens when there is some type of teacher on student assault. However, there is a slightly different analysis for when there is student on student sexual assaults. And those assaults could be occurring anywhere within school functions. It could be dormitories, it could be at a school play, or it could be essentially in the classroom. But Title IX covers both of those types of situations. However, there are some nuanced differences in the elements that need to be met and how you would actually present those claims.
Is it harder to prove one kind of case versus another?
Well, every case is different, and it's all based on the amount of evidence that we're able to obtain. Unfortunately, it is still the plaintiff's burden to present evidence that shows that there was not only actual notice, but there was also deliberate indifference to that notice. And witness testimony, proof can be had in various forms of evidence, but witness testimony is one that's very strong that we see time and time again in these claims.
One thing I'll add too is that we're often in a situation where we respond to someone's inquiry about whether they have a case, and we have to tell them that under the technical aspects of the law, they don't have a case, even though they were clearly harmed. And that's one aspect of these laws. There are so many particular standards that apply that some people may have a claim and some people may not. And that's just the reality of the way the law works.
And the reality is that the victim of the assault could bring a case directly against the perpetrator. But what you said earlier, Steve, is that a lot of times those people don't have any money to pay a damage award if there was one. Was that
right?
Right.
And so they were harmed, but there is no good recourse for them. And that's sometimes the reality that we have to tell people. But we often look for the opportunity to find the special facts and circumstances to make a difference for people.
All right. Thank you, gentlemen.
Thank you.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for joining us for In the Name of the Law. We look forward to having you again next week for another exciting episode.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.